Assalamu alaikum and welcome to Just Law on IQRA TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, on Just Law we normally discuss an area of law which is of interest to you, our viewers. Secondly, more importantly, Just Law is a live show. So whatever questions that you've got relating to English law, please do pick up the phone and give us a call, and hopefully we should be able to discuss those matters with you in greater detail. On this show, we should be able to cover matters as diverse as immigration matters, family matters, criminal matters, etc. So whatever your questions are relating to English law, please do give us a ring. Just a couple of matters before we get going, because it's a live show. Obviously, we're not able to discuss matters in a lot of detail. So if it transpires that I do need to speak to you, I will ask you to leave your number with the control room, and I will then call you back and have a more discussion with you off air. Secondly, because it's a live show, obviously I'm not able to look at your documents. Again, if it transpires that I do need to look at your documents before I can advise you, then I'll ask you to leave your number with the control room, and then we can have a discussion later on after you've managed to send the documents over to me. But in my experience, the vast majority of queries that we get, I should be able to answer those live on air as you call in. Right, so normally what we do is we pick a topic for the day. Today what I want to discuss is how European nationals living in the United Kingdom can make or support spouse applications for their spouses who are abroad. This is slightly different to applications made by those who are sponsored by those living in the UK who have a British passport, who have British citizenship, or who have indefinite leave to remain. Their rules are slightly different. What I want to do today is focus on European nationals, and in particular the partners of European nationals who may be in India, Pakistan, Bangladesh, wherever they are. It's how can a successful application be made to sponsor them to come in the United Kingdom on a permanent basis. And although that is the topic for today, as always, whatever your questions are, whatever they relate to, it's not a problem. You can ask those questions. It's not a problem that it doesn't specifically relate to the topic for the day. So let's just go back to this topic of European nationals who live in the United Kingdom who want to sponsor their husbands or wives, who are husband or wife who's abroad, to come to the United Kingdom. Now, as I've just said, the position of applicants who have a sponsor in the United Kingdom, where the sponsor has a European national, is different to the position of sponsors who have sponsors in the United Kingdom who are British or who have indefinite leave to remain. The rules are completely different. On the one hand, those who are British in the UK want to sponsor their husband or wife to come to the United Kingdom. For them, the rules that apply are the immigration rules. And there are specific rules about marriage, specific rules about income, specific rules about accommodation, etc. Whereas contrast that with the topic for today, which is where the sponsor has a European passport. So the sponsor might have come to live in the UK from a European country after they've acquired their citizenship there. So they might be living in the UK with a French passport, Portuguese passport, Spanish passport, Italian passport, whatever it is. So they're here and they want to sponsor their husband, their wife, their children to come to the United Kingdom. Now, the reason that we have a separate topic relating to this is because the rules are completely different. On the one hand, British sponsors have to, or their partners have to comply with normal immigration rules. Whereas on the other hand, where the sponsor in the UK is a European national, you have a completely different set of rules which apply, which are the European regulations which deal with the entry of family members into the United Kingdom. And as we go through the various categories which deal with the requirements which need to be fulfilled. What I will do is highlight the distinctions or the differences between where sponsors are European nationals and where sponsors are, which is the case in the vast majority of cases, where the sponsor is a British national or has indefinite leave to remain. The first category that we come across where the sponsor is a European national, the first distinction that we come across before we even look at the rules relates to fees. Typically for somebody whose sponsor is a British passport holder, and it's a normal application for a spouse which is being made, typically the fees are in the region of £2,200 for a spouse application. And if it's done on a fast track basis, there's an additional fee of approximately £600. So all in all, you're looking at around 2,200 to 2,800, where a normal spouse application is made to sponsor a husband or wife to come to the United Kingdom. Contrast that with the situation where the sponsor is a European national. There is no fee whatsoever to pay. There's no application fee, there's no NHS fee, there's nothing like that. There's absolutely no fee to pay at all. So that's a huge difference to begin with, and that's a fundamental difference in terms of how the application is actually made before we even get to looking at the actual application. Now, the second huge difference is when we look at the actual requirements. The second big difference relates to the English language requirement. As our callers will be aware, in a typical spouse application, the applicant who's abroad, whether they're in India, Pakistan, Bangladesh, the applicant must pass an English test. Now, there are some exceptions to that, but generally speaking, must pass an English test. And although the test is at quite a basic level, it's an A1 level in speaking and listening, there are many cases where it's not easy to pass that test and obtain the certificate that needs to be submitted with the application. So you do find cases where applicants go on a course, sit the test, but they fail the test. And they again do the same, go on a course, try and sit the test and pass it, but they still don't pass it. Now, the big advantage for those who are in the UK as European nationals and they want to sponsor their husband or wife to come to the United Kingdom is that there is no English test at all. So there's no A1 test, there's no A2 test, there's no B1 test. So there's no test at all that the applicant need to pass in their home country. And this advantage continues throughout the spouse process, where they get to the extension stage, even when they get to the indefinite leave stage. At no stage is there a requirement for them to pass an English test. That's the second fundamental difference. One is that they don't have to pay a fee where they are coming to join a European national. Secondly, they don't need to pass an English test. You can see very quickly that how the application is a much easier application for somebody who's coming here to join a European national. The third main difference is in relation to the income requirement. And this is something that we've discussed a number of times over the last few weeks, which is the main sort of problem with spouse applications, where you're calling a husband or wife over to the United Kingdom. There is a requirement that the sponsor in the UK needs to be earning 18,600 as a general rule. There are exceptions, there are different ways of meeting that requirement, etc. But generally speaking, and in practice, the vast majority of cases, I would say 90 to 95% of cases, turn on the sponsor having to earn 18,600 in the United Kingdom. Now, where the sponsor in the UK is a European national, that requirement doesn't apply at all. There is a requirement, which is that the sponsor in the UK does need to be what they say, or what they refer to as exercising treaty rights. Effectively, that means that a sponsor in the UK has to be employed or self-employed or a student or have sufficient means or sufficient income for them to be able to look after themselves without having to rely on public funds, etc. So they have to fall into one of those categories. But it's a much better way of meeting the rules than having to satisfy the 18,600 requirements. So that's the third huge fundamental difference. Now, this is something that we've discussed several times on previous shows. The problem with meeting the 18,600 requirement, the sponsor in general terms needs to be working for 6 months in the same employment, needs to be earning the equivalent of £18,600 per annum, needs to submit 6 months wage slips, 6 months bank statements, needs to submit an employment letter, etc. So in terms of the financial requirement for normal applications, not only is the requirement quite strict in terms of the earnings, but there are very strict requirements in terms of the documents that need to be submitted. Contrast that with what we've just discussed before, which is where the sponsor is a European national. First of all, the starting point is, let's compare a sponsor who's a European national who is in employment, so similar to a normal application where somebody is in employment. There is no requirement for that person to be earning 18,600. So how much do they need to be earning? Actually, the rules suggest that even somebody who's earning £100, £150 a week, that would be sufficient. What I normally advise clients is try and make sure that you earn enough so that you are actually paying some national insurance contributions, or if possible, you're paying something towards income tax. But even if you're not earning enough to pay income tax, try and earn enough money per week where you're paying at least a small amount of national insurance contributions at the very least. The reason I say that, and this is where somebody just needs to be earning £170, £180 a week. So as long as you're earning that amount of money, first of all, the Home Office will generally consider that to be genuine employment in terms of earnings. It's not like earning £50 a week or something where, you know, it could be argued that it's not real employment that you're in, it's just peripheral. At £170, £180 a week, the Home Office will accept in terms of the amount, it's genuine employment. And the second thing is that with that kind of income, you will actually be paying a small amount towards national insurance contributions. And what that will do is, with HMRC, there will be a record that you worked in that week and that you contributed whatever it is, if it's £5 a week, whatever it is, towards national insurance contributions. So at least there will be a record with HMRC in relation to your employment. So in that sense, the first huge difference is the amount. On the one hand, you've got the sponsor who is British, where you're trying to show 18,600, equivalent to about £355 a week. On the other hand, somebody who's earning even £170, £180 a week would meet the requirement that they are in receipt of income. So that's in terms of the amounts, there's a huge difference. Somebody coming to join a European national just has a much easier task on their hands in terms of meeting the financial requirements. So that's looking at the amount that needs to be shown. The next big issue is relating to how your income is demonstrated. Over the last few weeks, we've looked at how, to some extent, it's quite problematic to demonstrate an income of 18,600 or whatever it is, because the rules governing that is very, very strict. So typically, where somebody starts a new job, they would need to show an income over a period of 6 months. Contrast that with somebody who's making a European application, where it would be sufficient to even show income over 3 months as opposed to 6 months. So the period over which employment needs to be shown is hugely different as well. On the one hand, you must, generally speaking, show 6 months of employment. There are obviously, that's a general rule. There are differences where somebody's been in employment for a while, left their job and started a new job. But generally speaking, you would need to show income over a period of 6 months for your normal application. European application, my experience, employment over 3 months, 2-3 months would be sufficient as well. Next difference is the actual documentary evidence which needs to be submitted. The Home Office is very strict when it comes to normal applications where the sponsors are in the UK in terms of the wage slips. They've got to be up to date, particular format, etc. Look at the bank statements, they have to be up to date, cover the period of the wage slips, the format has to be right, etc. If you look at the employment letter which has to be submitted, again, the format, the information that needs to be in there is very prescriptive. So this very prescriptive approach to satisfying the immigration rules as far as the income requirement is concerned for normal UK British sponsors doesn't apply when somebody has a sponsor who is a European national living in the UK. For them, 3 months wage slips, 3 months bank statements, there's no strict rules about dates, etc. Obviously, you try and make sure they're up to date because you need to show that the sponsor is in employment, but there's no strict requirement as such in terms of dates, what periods it covers, in terms of, if you look at the employment letter, what the employment letter needs to cover as well. So there are huge differences in terms of how the income requirement is met. In terms of the amount, there's no amount for European nationals. In terms of the duration of the employment, there's no duration for the required duration of employment for European national sponsors, and again for the documentary evidence that needs to be submitted in support of an application where the sponsor in the UK is a European national. So there's a significant difference between those two in terms of meeting the income requirement. In my experience, in terms of, this is the third difference that we've looked at. The first huge difference is there's no fees to pay. The second difference, where the sponsor is a European national, is that there's no English language requirement. And the third difference is that the rules relating to income is quite relaxed. Now, in my experience, the biggest advantage in practice is the law relating to how the income requirement is met. In my experience, as far as applicants and sponsors are concerned, they're okay paying the Home Office fees to get the job done. In most cases, the sponsors there in the home country will pass the English test. So we'll look at that in greater detail. Let's take our next call. Hello, assalamu alaikum.
Wa Islam, brother.
Thank you, brother, for calling. Yes, brother, what's your question, brother?
Brother, I want to just ask you a question. Is regarding, I've been married before.
Okay.
And my wife's here in this country.
All right, okay.
She's from this country as well.
Okay.
But we've not had no children in the past 4 years.
Okay.
Now she's asked me to get married again.
All right, okay.
So now I'm thinking of getting married from Morocco.
Right, okay.
But is that legal to do in this country, or what is around it?
Morocco seems to be a very popular destination for second marriages. Okay, I think there's a couple of things we need to look at. One is, in terms of your marriage, I can certainly advise on that. But the second issue is, are you thinking of sponsoring your second wife to come to the United Kingdom as well?
Yeah.
Okay, second wife to come to the UK. And in terms of the marriage to your first wife, obviously you've said that she's okay with it.
Yeah.
Okay, right, okay. Well, let's look at the first issue. One is the second marriage. Generally speaking, in terms of the law, what you look at is whether the marriage that's going to take place in the country where it's going to take place, whether it's permitted or not. Now, obviously, in the United Kingdom, it is not permitted. And it's actually a criminal offence to go through a second civil marriage, where you're already married. To go through a second civil marriage is actually a criminal offence, which is quite a serious offence in the United Kingdom, because UK law does not permit that at all. So you have to bear that in mind, that as far as the UK is concerned, it's not permitted. Now, that's a civil marriage, in the second civil marriage in the UK. Now, as far as Morocco is concerned, I think my understanding is the position is quite different, because that marriage is permitted under the law in Morocco, because it is permitted. So in that sense, although you would be able to get married in Morocco, I think the difficulty here is, how do you sponsor your second wife to come to the United Kingdom? that would be very, very difficult indeed, because as far as UK immigration rules are concerned, they won't permit you to understandably sponsor a second wife to come to the United Kingdom. So in terms of your marriage, fine, but in terms of your any attempt to try and sponsor your wife to come to the United Kingdom, that may well be very problematic for you.
I understand that, but you know, like my first man, obviously she's happy with me going ahead with this.
Okay.
Yeah, obviously we don't want to go through a divorce.
I understand. Well, look, the problem is, I understand what you're saying, that your wife is happy with it. The problem is the way UK immigration rules actually work. The rules relating to this particular situation doesn't take into account whether your wife is consenting or not. And from what you're saying, you're a lucky man, your wife seems to be consenting to your second marriage, which is obviously permitted under Islamic law. Now, but the issue for you really is that as far as any future immigration applications are concerned, the Home Office does not look at whether your wife consents or not. What it does look at is whether you were free to marry or not, legally free to marry or not. And because as far as UK law is concerned, you were still married to your first wife. Although your second marriage may be legal, as far as UK law is concerned, you were not free to marry, and therefore you would not be able to sponsor your other wife to come to the United Kingdom. I think that's where the problem is going to be. Now, there may be other categories under which she can come to the United Kingdom. She may be able to come as a visitor if she wants to come and visit. If she wants to come and study in the UK, that may be a way of coming to the UK. But in terms of coming as your wife, that on the face of it seems to be problematic for you. So maybe that's something that you just need to give some thought to. Yeah, brother, thank you very much for your call. Interesting call. Thank you very much. It's a very interesting call there. Thank you very much indeed for that call. Now, just going back to what we were looking at, and really today we're focusing on spouse applications where the sponsor in the United Kingdom doesn't have a British passport, but what they do have is a European passport. So it may be that the sponsor in the UK who wants to call their husband or wife from abroad, maybe has a Spanish passport, a Portuguese passport, Italian passport, they're living and working in the UK and they want to call the husband or wife over. We were looking at what the main differences are when that application is made. As I said at the outset, one is there's no fee payable. Secondly, there's no English language requirement which needs to be fulfilled. And thirdly, the big huge difference as far as how the income requirement is met. On the one hand, with a normal application, if I can call it that, where the sponsor is British, a sponsor would normally show an income of £18,600. Where the sponsor is a European national, there's no need for that. You could get away with just showing that the sponsor in the UK is in employment, possibly earning £170, £180 a week. So in one sense, it's much easier to satisfy that requirement. Now, this is the fourth difference that I want to look at, is in relation to the law relating to accommodation. Now, I'll look at that in greater detail after the next call. Hello, assalamu alaikum.
Sam, I've just got a quick question.
Right, okay.
If someone was married in the UK,
right,
and he went back home and got married, would he be able to call his second wife here?
As long as he is married to his first wife, he wouldn't be able to call his second wife as far as the UK immigration rules are concerned. He wouldn't.
Even though he's a British citizen?
No, even though he's a British citizen, because he, as far as the UK law is concerned, although he may be legally married, as far as his second marriage is concerned, he may be legally married to the second wife in Pakistan or wherever. But as far as the UK immigration rules are concerned, they do not consider that person to be somebody who was free to marry. So, that would be problematic. They wouldn't be. Well, it depends how you look at it.
There's no way that he can call his second wife over?
No, there isn't. Now, what sometimes happens is that maybe the first marriage has actually broken down. So what then tends to happen is that when the husband or ex-husband decides to get married and he's got somebody else there, and if the first marriage has broken down, then what tends to happen is it's at that stage that they start divorce proceedings, and they then try and obtain a divorce from their first wife. Now that
so the only way he can call her down is if he divorces the first wife.
it divorces the first wife. That's what they do. Now look at that in greater detail. After we're just going to take a short break. After we come back, we'll look at this particular question in greater detail.